Massive immigration changes in 2026 for green card holders. I'm your immigration attorney, Sekou Clarke, and in this video, I want to go over the 4 major changes that will affect green card holders, whether you are currently a green card holder or you are applying for your green card holder. So these changes are changes that I've seen within my firm based on applications from last year, but also changes that have come directly from DHS, USCIS, and DOS. But what I also want to do in this video, not just only talk about the changes, but also how you can be prepared for these changes, how you can navigate these changes, but more importantly, how to make better decisions when you are applying for your green card, whether it's through marriage, whether it's through a family member, or just to make sure that you keep your green card in 2026. As you know, immigration in 2026 has been off to a movie-like start. After practicing immigration for almost 10 years, and my firm has done a phenomenal job of, 2025, we had our most approvals in 2025. So what does that mean? The Trump administration is still approving green cards. Immigration is still moving. Immigration is still one of the #1 ways to get to your American dream, your version of the American dream. That is my goal for you, is to educate you today as to how you will navigate these challenges. So let's get into it. The number 4 biggest changes in immigration in 2026. So number 1, mandatory entry and exit for biometrics. So that means for green card holders, what the Trump administration has done, and there are going to be people who said that this was always a thing. No, it wasn't always used to the level that it is being used now. Is that when you leave the country as a green card holder and when you re-enter the country as a green card holder, they will be taking your biometrics. But what will they be doing with those biometrics? They will be scrutinizing your travel history. They will be scrutinizing your immigration history. They will be scrutinizing your social media history to flag if you have said anything anti-Semitic, anything that goes against US policy, anything that violates the terms of your green card. So I've already done consultations in 2026 where people have gotten a notice. And yes, today is the 10th of January. And I have done a consultation where someone has gotten a notice for rescission of their green card based on travel that they did in 2025 in December. So people, if you have your green card, make sure you know what you're posting on social media. Of course, you can't have any type of criminal history, right? And you have to be careful of what you say and who you say it to. You just never know what might happen. Number 2, the increased scrutiny of marriage-based petition. I cannot stress this enough. Marriage-based petitions will be increasingly more difficult in 2026. All right, so the first thing that we've seen is that from the 19 high-risk countries, they have completely halted the immigration process through marriage for the 19 high-risk countries like Nigeria, Burkina Faso, Sudan, Syria, Palestine, right? And there will be significantly more scrutiny when they evaluate your case for fraud. What is marriage-based fraud? It means that you entered into a marriage for the sole purpose to evade US immigration laws, meaning the marriage was not real. Of course, everybody knows that this has been a thing for USCIS for decades, but in 2026, they have significantly more tools, right? They have TSA tools, they have social media tools, they have IRS tools. They have significantly more tools in which they will be scrutinizing your marriage-based petition. They have also mandated immigration interviews, right? There's no more waivers whatsoever. I mean, there's still some here and there where the interview will get waived, but they are now requiring for almost all marriage-based petitions that you must show up in person. And guess what, people? They don't care. It does not matter. You must be living together. They don't care about if you are working somewhere else. They want to know that this marriage is bona fide and you are living together. So marriage fraud, they're going to be going after that. They're going to be ramping it up, and they're going to be using your lengthy immigration history from the way how you entered. I just had a recent client who came to me, and they denied the marriage-based petition, right? Not because the marriage wasn't bona fide, but because when the husband entered the country, he made a misrepresentation when he applied for his B1, B2 visa. Yes, we can resolve the case, but this case was denied because of that. So these are the things that's happening. So the way how we would fix that case is we would actually have to refile, but do it with a waiver for misrepresentation. But it just goes to show the level of scrutiny that is coming for marriage-based petitions. They are cracking down on every single area of immigration, especially as it relates to green card holders in 2026. Number 3, the public charge. Now, some people are saying this has been like this for years, for decades, etc. They have been doing this, but guess what? They rarely enforced it. So it is revamped, and they will be denying cases if the spouse, such as the US citizen spouse or the immigrant, has once used like SNAP benefits, Section 8 housing. They will be using the public charge rule to deny cases. Mind you, in 2025, USCIS officers had the most power, right? In the history of immigration, USCIS officers had the most power. They were emboldened, right? To where they can deny a case before it even gets to interview, where they can refer a case directly to immigration court at the interview, or they can have ICE directly at the interview. They have done that significantly more in 2025. So immigration officers, right, they can and they will deny cases for the use of public funds. And people, yes, I know you're going to say this has been around for a long time. A lot of laws have been around for a long time, but guess what? In 2026, they are bringing them all back. And last but not least, when it comes down to your green card renewals, right? The I-90, the form that you must use to renew your green card, they are expecting to hike the fees on that. And not only that, they will be extending the waiting time in which you can receive that renewal. But most of all, there will be more scrutiny before they renew that green card, right? They're going to go back further into your immigration history, and it's almost like they're re-evaluating the validity of your green card to see if the way how you attained that green card, if it was by fraud, if something was missed. And these are for people who have had their green card for years. These are the things that they will do. So number 4, it's the renewal of the green card. They will be doing significantly more scrutiny. It's no longer just a stamp and reissue. They're going to be reopening that file in 2026 to look at your immigration history. But what can you do, right, with all of these changes that have happened? The number one thing that I always say is you be prepared. How are you going to be prepared in 2026? You're going to stay on top of the immigration laws, meaning you know them. If you are filing for your green card, no matter if you have an attorney or a document preparer, you must also know what you are doing. You must make sure you have a copy of every single thing that was filed on your behalf. And you must also use a professional. You definitely have to do that. Use a professional with experience. But nobody's going to know your immigration case more or better than the way how you do. The second thing that you can do is preserve evidence for any type of green card application, right? Whether it's for your child, through your child, from a parent, or through marriage. What drives a case now is evidence, right? Is evidence and preparation. make sure you have if you know you're going to file for a green card, before you put in that application, from the minute that thought comes in your mind, make sure that you are saving the different types of evidence that you think you might need. Of course, a professional will prepare, but screenshots of social media, birth certificates, marriage certificates, every single thing that you think you will need, you start creating an organized folder for these things. My most successful clients, granted, we have done some really, really good work on cases, but my most successful clients are the ones who come in already prepared, right? And you might ask yourself, well, why do they need a lawyer if they're coming in already prepared? Because we can make it better, and we will make it better, because there are certain things within 10 years that we have done, that we have seen, that we can add to our file that's even significantly more prepared. But once you bring the file prepared, it puts us into a better position to even doing our job better. I'll never forget this client. She came in with an organized folder of pictures. It's in chronological order, and I was like, wow. So that allows us to write better affidavits, to come up with better evidence, because no evidence fits one case the same way. All right. And of course, last but not least, being prepared. Do not go to any immigration interview or hearing without being prepared, without practicing. Even if it's by yourself, make sure you know what relief you have. Make sure if it's your child, your parent, your spouse, you are practicing together. Your attorney should have you practicing, but you should be practicing on your own. Nobody will know your immigration case better than you do. So in 2026, you cannot stop the changes. You cannot stop the changes, but you can control what you can control. Being prepared, having the right evidence, knowing your case better than anybody else. Those are some of the major things that you must get right in 2026.